Okay, good afternoon again, everyone. Welcome back to Business Law 2. Today we're looking at Chapter 39, which is liability of the principal and agent, as well as the termination of agency. And so there will be a little bit of overlap with Chapter 38, which we previously have covered, which involves the creation of that principal-agent relationship. So in this chapter, in terms of overall learning objectives, I want us to understand the principal's liability in contract. We'll talk about the principal's liability in tort, any potential criminal liability of the principal, and then we'll understand the agent's role of personal liability in tort and contract, as well as how this agency relationship is terminated under the law. So that's, the big focus for this chapter. So I showed this slide in Chapter 38, so just to kind of quickly review it, in terms of a principal's liability, that requires that the agent has had some type of actual authority, and so authority can be based on different foundations. It could be express, and so that's where there's an actual written agreement between the principal and the agent that is executed, meaning signed. And so it's very clear, this is my person, he or she, they're going to make these decisions and enter into contracts on my behalf. That's express. Implied is where an agent has implied authority to perform acts incidental to carrying out whatever the underlying transaction is. And then the apparent, that's where, that example of the horse farm that I gave in Chapter 38, that's where you have the appearance of authority. And sometimes regardless of whether or not there was actual authority, if neutral third parties, people that do not know the principal or the agent, were to come across this situation, would they perceive, based on statements or other factors, signs, indicating this is the manager directing queries, to this on-site manager, whatever it is, then that would be apparent authority as the form of agency creation. So in terms of ratification, a principal can ratify a previously unauthorized agent by any one of the following. So actual performance of the contract. So maybe maybe I say, I'm your agent and I'm going to go find, a contract for you. And you may be like, well, you're not my agent, but I come back the next day and let's say it's a really lucrative contract for you. It's like a great deal. And you're like, okay, fine, I'll actually perform on this. Well, that's ratifying the fact that I am now your agent. If you accept the benefits of a contract, if you enforce the contract, if you fail to disavow the contract, those are other ways in which that all can be interpreted as ratification. And ratification means I'm your agent at that point. So usually the requirements for ratification, you have to have the intent. The agent has been contracted for an identified principal. The principal had capacity to contract, and the principal has full knowledge of all the facts. And as long as that's all satisfied, then we can say that ratification has occurred. Burden of proof, so this is an evidentiary standard in a court of law. So let's say there's a dispute legally between the principal and the agent. The burden of proof rests on the party who seeks to benefit from its existence. So if you are denying that I'm your agent, and I'm like, no, I have this contract, and you were accepting the benefits of it, and I'm suing you now because I want to get compensated. I obviously have that burden of proof saying, look, I entered into this contract for the principal. I delivered the contract. I delivered a customer, and that contract was satisfied. And because of that, I'm owed money as per what an agent would get compensated for. That's the burden of proof. Agency duties and liabilities. So in terms of what the principal owes the agent, whether it's in contract, tort, or maybe if it's under some sort of statutory provision like workers' compensation law, contract duties, normally the principal cannot interfere with the agent's performance of his or her job. And so agents also do need to be informed of any potential job-related dangers because that can arise. If we're talking about torts, and so that's personal injury, if you remember that from Business Law 1, or workers' compensation duties. Normally when injuries occur, if it's an employee, and that could possibly include agents, then normally tort law doesn't apply. That's a workers' comp thing. And so, workers' comp provides for coverage, whatever your injury is, which is great, but it doesn't provide for, let's say, pain and suffering necessarily. It only provides your actual and direct medical costs. So, but if you're deemed not to be an agent or an employee and you're just an outsider, then obviously tort law could be a possible cause of action at that point. If we're talking about liability of principals to third persons, so liability of the principal depends upon two factors: the extent of disclosure that the agent made to this third party about who they are working for, and then the form of contract. So if it's a simple contract and the principal is disclosed, normally in that case the agent is not going to be a party to the contract, and they're not going to be liable if there's a performance or breach issue. The principal would be fully liable. So let's say with Walt Disney that he didn't try and disclose his identity. Let's just say that he sent agents out and he told the agents that you can tell these sellers of land that you work for Walt Disney. So if there's a contract dispute, those agents wouldn't have to worry about being sued because Walt Disney has been identified. And so they're just going to sue Walt Disney directly, the sellers of their land. If you have a simple contract and let's say it's a partially disclosed principal, here the third party that has entered into a contract with the agent on behalf of a principal, maybe the fact that the agent is working for a principal is disclosed, but then you don't identify who that party is. Maybe you say, yes, I'm working for a land developer, but I'm not going to tell you who it is. If that's the case, then that third party, if there is a breach of some kind, then the agent or principal can be sued. And the theory there is joint several liability. That's a fancy term that means that the agent or the principal can be sued either independently or collectively, and each are responsible in its entirety for whatever harm has befallen that third party. The last category is where it's, again, let's say it's a simple contract where you have an undisclosed principal, so the agent never reveals that they're working for a third party. Here, the third party may recover from either the agent or the principal. It's also joint several liability, but they're not going to ever figure out who that principal is. So they're going to, in reality, just be going after the agent in that case. So again, these are just some general types of liability and triggers that can incur for principals versus agents in the realm of liability as a whole. When we talk about tort liability, so personal injury, if we're talking about direct liability, if an agent is directed to commit a tort, the principal is liable. There's no question about that. One cannot escape liability by delegating an unlawful act to someone else. So the agent is going to be responsible as well, but you can also pull in the principal at that point. The idea of vicarious liability, this is also known as respondeat superior liability, and it's a subset in the world of torts. That's where the principal is going to be held responsible for acts committed by an agent if that is within the scope of the employment. And so I'll give an example at the end of this that'll hopefully make a little more sense. But usually things that we ask, in terms of types of agents creating tort liability, usually it arises from employment, not necessarily agency status. Is the principal liable for intentional torts? And again, the question is, was the agent acting in furtherance of the principal's business? If so, then yes. If not, then no. And then the last one is, was the agent acting within the scope of employment? So deviation from scope, and sometimes it's called like a minor frolic. Courts look at the mindset of the employee. So classic example of the minor frolic. When I was in law school, there was a chain of tire stores out west. And one of the employees, who changed tires and did like rotation and balancing, normally when, you guys know, we've all been there, you drop your car off and let's say, you get your tires rotated, maybe you get new tires. And so part of what, these mechanics do is when they're finished, they take the car for a test drive, and to make sure everything is balanced and in working order. And if there's an issue, they can tweak it, and then they have to probably test drive it again. But anyway, they take it for a test drive. So this one employee, he had the habit of, he would like work in the morning on doing tire changes, and then when lunchtime came, he would take one of the vehicles that he would go on a test drive with, and then he would go get lunch. So technically was a test drive, but then he did kind of frolic or deviate, and he would sometimes go home for lunch, or he'd go to a restaurant for lunch, and then he'd come back and then call the customer and say, hey, your car's ready, no problem. Well, in one of these frolics, the driver got into a car accident, and it was very apparent because they were like 30 minutes from the tire store, and so there was no way that you could articulate that was part of a regular kind of like road test, because road tests wouldn't take you 30 minutes away from that tire location. So the manager knew of these frolics, and the manager never said anything. And so because of that, you are owning that particular liability. And so the harm that befell that car, it's going to fall not just on the driver, which was the employee, but it's also going to fall on the business in terms of liability. So that's that idea of like respondent superior liability. Now, an example where maybe that's going to be outside the scope. This is a Florida case, and obviously Florida cases are crazy cases. There was a hotel where an employee was vacuuming the lobby, and in the process of vacuuming, I think they had lifted up the vacuum, and they hit the leg of a guest, and hit the guest's leg pretty hard, so they end up going to the hospital. So okay, that's fine. That there's no question that's respondent superior liability. The employee was furthering the interest of the employer, the hotel, because they were vacuuming. Okay, fine. Different employee, same hotel. For some reason, fighting words erupted with a guest. So it's the employee and a guest that are arguing, and the employee then struck the guest, physically punched them in the face, and of course went to the hospital. That would not be respondent superior liability, because that is not in furtherance of the business. At least it shouldn't be. And so the liability in that case falls directly on the employee, which now probably is going to be terminated, hopefully, for striking a guest. So again, liability can trigger in unusual ways, but the key thing is that it has to be in furtherance of the business. One final example of respondent superior liability was this happened in New York City. There was a case involving a cab driver and a car. I was going to say pedestrian, but that's not the accurate term. There was just another car driven by just a average person. They pulled out in front of the cab, and the cab couldn't stop in time, and so ran into this other car. So the cab driver did not cause the accident, but was involved in an accident. And so the cab driver got out and had a crowbar, under his seat. He pulled the crowbar out, and he went to the driver of the other vehicle and beat that person with it. And again, you're thinking, okay, this is not in furtherance of obviously what the cab company is about. And so in that case, there's not going to be liability on the management or the cab company owner. That personal injury, which is a tort, it's an intentional tort, assault and battery, that falls just on the driver as an individual. So interesting cases. I mean, unusual, obviously, but interesting cases from a legal perspective. So, respondent superior liability, just remember, it can be triggered in a variety of different ways. As long as it's, under the course of employment, and the person is an employee, and, the nature of the act, that nexus of liability can transfer to not just the person, but also the employer. When we talk about the nature of the act, that could be a couple of different situations. It could be negligent acts, so that's within the scope of employment. Intentional acts, if it's in furtherance of the employer's business. Fraud, if it's in furtherance of the employer's business. Some states require actual knowledge on the part of the employer. It just depends on the state. And then if it's a governmental regulation, the employer is liable if federal regs are violated. And so that's kind of a more nuanced area of the law in terms of governmental regulations. But again, you get the idea of what level is required depending on the act in terms of triggering liability onto another party, which usually we're referring to the employer. The last slide that I have for this chapter, in terms of agency and employment, related to this idea of responding to superior liability is also the idea of like negligent hiring and retention. And so if you hire or rehire or keep employed people that have questionable, records, that also is a way of inferring liability. Here, another Florida case. I love these Florida cases. There was an airline, small airline rental company in the Florida Keys. And one of the pilots that they used, who kind of flew different planes for some of their owners of different planes, he had a history of being very reckless with planes. Like he would take off from like a local landing strip in the Keys, and he would have no destination listed. It would be like a joyride, and so he had been in trouble with the FAA for a variety of reasons, for not having flight logs, taking off without permission or authorization, and so on. Yet this small flight company down in South Florida in the Keys, they actually would fire the person and then like a week later hire him back. And so this person who regularly got in trouble, they got reprimanded, they got fired, they get rehired back. And there was finally a case where the person took this plane, and before they even was able to take off, the plane crashed because the guy was flying erratic, and so because of that haphazard or negligent hiring rehire history relationship that the employer had with this pilot, liability transferred to the employer as well as that pilot. So again, this does bring up kind of like a challenging subject if you're talking about hiring people that have had issues with the law. Let's say they have a conviction of felony or misdemeanor. You want to try and give people the benefit of the doubt. I believe you can turn your life around. There's no question about that. But you do have to be very careful, when you do that, because if depending on the nature of what got them into trouble with the law, if you're not careful in how you're handling them as an employer, when they do things that maybe are violating the law again, potentially, that liability is going to get transferred to you as well. So anyway, please let me know if you have questions about this principal-agent relationship. But hopefully, again, this sheds a little bit of light on a very interesting area of the law. As you have questions, just forward them to me. You can call me, text me, email me, whatever is easier. Otherwise, I hope each and every one of you has a very safe, productive, and just good week. So I'll be chatting with you all online. Thank you so much. Bye-bye.